Good morning, everyone. Welcome to this webinar on investigations for charities. My name's Jo Oliver. I'm a partner in the employment team here at VWV, and I'm joined today by Simon Martin, who's a really experienced HR consultant from Narrowkey HR. Um, we both routinely work with charities and we help them in situations that are complex, difficult, and challenging in the workplace. And that often involves carrying out an investigation. So today, what we're going to do is talk you through the legal considerations when you launch an investigation and then walk you through some of the more practical elements of conducting a workplace investigation. The main focus is going to be on employment investigations, but a lot of what we talk about will be applicable to other things, so complaints and other investigations that you might need to conduct. The session is going to last about an hour, but a bit of a disclaimer, it's normally a 2-hour training session, so we've tried to condense as much as possible, but we may run right to time and we may not have time for that many questions, but we'll do our best to get to everything. You'll get a copy of the slides and you'll get access to a recording of the session as well if you want to rewatch it at any point or share it with your colleagues. So, kicking off, before you get started with an investigation, it's really important to think about what the purpose of that investigation is. So, essentially, it's going to be a fact finding exercise. You're not there to find evidence to support a particular viewpoint or to find someone guilty of something. It's an impartial investigation, gathering of facts to be able to allow you as the employer to make an informed and fair decision on an issue or a complaint. So, as I say, it's not about finding someone guilty, but it's about finding out what happened on the balance of probabilities and gathering reliable, relevant information to allow the decision maker to come to an informed decision. Um, if we move on to the next slide, please. There are a number of different circumstances in the workplace where an investigation might be needed, and that might be because a disciplinary concern's been raised. So there might be an issue of misconduct or persistent poor behaviour that you need to address. There might be a grievance raised or a complaint about a member of staff from a colleague or externally, um, and that you need to get to the bottom of what's happened in relation to that to understand what needs to be done in relation to it. There might be allegations of bullying, discrimination, harassment that you need to understand and need to resolve. And there could be safeguarding concerns. So, those of you who operate schools, for example, there may be a concern raised about a member of staff of a safeguarding nature that you need to um, uh, investigate, understand what's happened, and take relevant action, both to protect the child involved or the vulnerable person, and also because of your regulatory requirements. There's also circumstances where someone may have blown the whistle on a wrongdoing or breach of a legal obligation or a health and safety issue in the workplace, and you need to investigate that concern to understand whether there is a liability or risk or something that needs to be done in relation to it. And you might also get complaints from members of the public or service users and need to investigate those. So there's many different reasons why there might be an investigation needed. And the first thing that you would want to do is identify, is there an appropriate policy that guides how you need to conduct that investigation? So it may be that you have a whistleblowing policy or disciplinary policy that will set out the timeframes for an investigation, who should conduct it, um, and it's important you follow your policies and procedures where possible to do so. In some circumstances, it might not be clear right at the very beginning whether it's a disciplinary or a conduct issue, or whether it could be a capability issue or something else. And so it is fine to start an investigation to look into that issue. And once the findings are with you, you can then determine actually it's not a misconduct issue, it's a capability issue, and we'll adopt that policy going forwards. So you don't have to nail your colours to the mast right at the outset of the investigation if you're not sure where that complaint might take you. But it's important to think about what policies might be applicable. And most of the time, it's quite clear which one it will be. You need to think about relevant time limits. So, an investigation that takes an unreasonable amount of time or takes longer than would be necessary, could cause an issue in terms of the people involved making complaints about the process. It could mean that evidence is lost. It could be that memories fade. So it's important to act promptly and to investigate quickly, but that shouldn't be at the expense of being thorough in the inquiries that are made. And quite often you'll see within your policies that there are timeframes for when a first meeting might happen, and that can guide the speed of which an investigation takes place. In some circumstances, you'll know from the outset that those time limits are going to be difficult to meet because it's a really complex matter and it's likely to involve the need to interview lots of different people. And if you know that at the beginning, and if you know it's going to take longer than expected timeframes, it's really important to communicate that to everybody involved so that you're setting the expectation that people aren't left wondering what's happening, and that they understand the reasons why it might take longer than expected. And usually, where you've got complicated discrimination complaints, for example, or issues where someone may raise concerns about institutional discrimination, when you need to take lots of views from lots of different places around the organisation, those investigations can take a number of months. And it's important to be clear from the outset that that's what's happening and that things are progressing, but there's lots of interviews to be conducted, and that's why it may take longer than expected. Thinking about who the investigating officer should be is also really important. In a disciplinary context, for example, the investigating officer needs to be a different person than the decision maker at a disciplinary hearing. So you need to make sure there's that separation of responsibility. The investigating officer needs to be someone who has been trained on how to conduct an investigation, that has the right level of expertise, the right level of seniority, that they're not biased or conflicted in any way, so that they're not been involved in the incidents that they're investigating, or they're not, or haven't had any interactions with the people concerned in the past that might lead to some prejudice in their view or bias in their views. So it's really important in terms of the principles of fairness that right at the beginning you think about, is the person the right person to be investigating? Do they have the right skill set? Are there any biases? Have they been trained? And in some circumstances, it's entirely appropriate to bring in someone external. So bringing in HR consultants or lawyers to undertake investigations where you need to have that level of impartiality, that separation, because they're really serious um, issues that you need to show that you have had that sort of hands-off approach and that you are approaching it from an impartial perspective. The next thing to think about is setting terms of reference for an investigation. Um, this is a really, really important step to take, and it often gets missed because there's a need to move things forward. Sometimes there's not that moment of thinking, what is it that we're actually tasking the investigator to do? How do we want them to go about it? When do we need to hear from them with their findings? Who do we think they need to interview? All of those questions are, it serves the organisation really well if you record them in a terms of reference. So you set clear parameters for your investigator of what they're being tasked to do, how they should go about it, what evidence that you've got for them to review, and where they can go to find further evidence. Um, Setting out a preliminary witness list, for example, of the people who are mentioned in a grievance or in a disciplinary matter so that they know who to start their investigation with. And it may be that naturally leads on to speaking to other people who may have witnessed it, but setting that out at the outset to give them a steer of what it is that you're expecting from them, who should receive the report when they have completed their investigation, referring them to the need for confidentiality in the process, but making it clear to them that there should be an expectation given to the people who contribute to the investigation that their interview notes, their statements, things that they contribute will be shared as far as they are is necessary with the decision maker and the people involved to allow for a fair process to take place. And it also avoids Scope creep. So if you set clear parameters, you're not in a position where you get a report back that goes off in lots of different directions and isn't really covering what you wanted that investigation to cover. And then thinking about preserving evidence, it's important that if you've got CCTV, that often gets overwritten on a regular basis. So if something's been recorded, making sure you retain it, preserving emails, other documents, making sure that they're available to the investigator is important. And also, at the early stages, before you launch into your investigation, particularly if it's a safeguarding issue or something that may be a criminal offence, you need to think about referrals to external agencies. So it may be from a school's perspective, for example, you might need to report to the LADO before you even start your investigation if there's a concern about safeguarding. If there's a misconduct issue that could be theft or dishonesty, fraud, you'd want to refer matters to the police to make sure that you're not overstepping into their investigation and interfering with their inquiries. And then suspension is something to consider as well. Do you need to suspend the people involved to ensure that the investigation process isn't compromised in any way? Are any of the people involved in the investigation or witnesses likely to be intimidated by having the person at the centre of the allegation still in the workplace? Could that person interfere with evidence or delete evidence, destroy evidence if they're in the workplace? So thinking about suspension is sensible, and communicating to anyone suspended what the terms of their suspension are. If we could move on to the next slide, please. So if we think about the employment law framework for the test of fairness, so this is a case from the 1970s. It's still good law. It's British Home Stores and Birchill, and it talks about um, the need for the employer to have a belief in someone's guilt in terms of misconduct. So they need to believe that that person is guilty of misconduct, but that can't just be an opinion based on nothing or their own view. It has to be based on reasonable grounds. And the way in which you would have reasonable grounds for believing something is if you conducted a reasonable investigation and you've made reasonable inquiries to understand the facts of the incident, and you can make a assessment of whether the allegations are upheld from that information. So it's that three-stage test, but the cornerstone of that test is a reasonable investigation. So often a dismissal for misconduct can be found to be unfair if the investigation right at the heart of it is tainted in any way, hasn't been robust enough, hasn't looked objectively at the evidence. So it's really important to mitigate against unfair dismissal decisions to ensure that you have carried out a really clear and thorough investigation from the beginning. And the ACAS code and ACAS guidance is really helpful in terms of looking at process and what's expected. In terms of investigations, they just need to be reasonable, and that's a proportionate exercise in terms of the resources of your charity. You need to be thinking about who's available to do the investigation, how serious are the matters that are being investigated, to determine how much resource is put into that investigation, how far that investigation goes. You need to make sure that it's a balancing exercise, but the test is what's reasonable. And then when you're looking at the fairness overall of a process, if you're looking at a misconduct, disciplinary issue, you'll be looking at not only the investigation, but having a hearing, delivering an outcome in writing, and giving the individual the opportunity to appeal. And that's all the basis of any fair process, following the ACAS code. And it's important to do that on the basis that if you fail to do it, the disciplinary dismissal could be seen as procedurally unfair, and there could be a risk of an uplift in any compensation as well, up to 25%. So that covers the sort of legal background in a very whistle-stop tour. I'm going to hand over to Simon now to talk you through from a more practical perspective on conducting investigations.
Hello, everyone. So in my session, we're going to talk about the process to follow with an investigation, the skills you need, and some of the tricky issues that are going to come up. So let's move on to the next slide, please. So Joe's already touched on some of this. So it's important that the investigation officer is impartial, and Joe's talked about that. The skills, I think the best skill for an investigation officer is being curious. So just wanting to know what's gone on, um, but also I think an ability to process and analyze quite a lot of evidence, because you will be gathering evidence, documentary evidence, interview evidence, and then it's the ability to synthesize all that and pull out some themes of it. And then the next one is time. So that falls into two headings. One is you just got time generally to do it, so it's not always going to be fourth or fifth on your to-do list. And this is often the reason that we're instructed, because if in a big investigation, people just don't have the time to do it. The other one is, and this really comes into focus because of the new this issue about the trauma-informed investigations. This is a new concept, a relatively new concept, where people who have been subject to allegation, or there's an allegation of sexual harassment, they're going to find it difficult to talk about. And so people being interviewed in those situations, you're going to have to be very careful and very sensitive. And you need to make sure you allow enough time in those investigations for them to be able to talk. And it may take some time. And so you, as the investigator, don't want to find yourself in a position where you are looking at your watch thinking, well, I've got a meeting in 10 minutes, so we need to hurry this along. So it's important that you can say genuinely take as much time as you need. Right, let's move on to the next slide, please. So Joe's already talked about terms of reference. It's so important because it tells the investigator what the questions are that they need answers to. And so, for instance, if there's been a grievance raised, the grievance might cover 20 different subjects. Some grievance letters we see are sort of 15, 20 pages. And it might be that the organization will only want actually 5 issues looking into, because some of those issues may have already been dealt with previously. So it's important that you're clear with your investigator the areas you want them to cover, because when I'm doing investigations, those terms of reference, those questions are central in my decisions about who do I need to interview and what questions I'm going to need to ask them. So, and during the interview, I'm thinking of those terms of reference questions. And when I come to write my investigation report, page 1 of the investigation report has those questions set out in it. So it runs through the entire process. So it's very clear, it's very important that the investigator is clear what questions they need to be answering. So next slide, please. So you're preparing for the investigation meetings, the interviews. You should definitely be preparing questions. Now, we do see quite a lot of situations where, let's say, a manager has asked the HR team to write the questions for them, and the manager then effectively just reads those questions out. That's a problem, because when you are in those interviews, usually the most important questions are the ones that are in response to the answers you're getting. So it's important that the questions are only a starting point. The questions should be based on the points in the terms of reference, but really they are just a starting point. Then think about getting a note taker, or increasingly whether you've got any AI that may, AI following a transcript that may be able to assist you. But it's important that when you're doing the interview, you are thinking about the answers you're getting, watching their body language, watching how they are answering. So it's important that you've got someone else to do the notes, because you want to be concentrating on the answers you're getting and how those answers are being given. The next point is confidentiality. So you want to let the people know um, before the interview that this is a confidential process, and not to share their involvement with anyone. So next slide, please. So you're in the investigation, in the interview. So the first thing you do is you should be reminding them of the importance of confidentiality, and also the use of their evidence. And so You need to be saying, I may need to refer to what you're saying in a conversation with others, and where the interview notes will end up. And certainly when we're doing the investigations, they'll be appended to the investigation report. So you can't give any promises about where the evidence is going to be given, where it's going to be used, but it's important that they know that the evidence they're giving is may well be shared with other people, and other people may see it, or bits of it. So next slide, please. So I think the most important, most helpful phrase as an investigator is help me understand. It's that curious approach you need to have. So you need to be wanting to understand very clearly what's gone on. You're not there to prove a case one way or another. Your job is just to want to understand what's going on. And so, particularly in grievances, quite often in grievance, it might cover quite a long period and quite a lot of different issues. And so you need to understand the detail of what happened, when it happened, and who else witnessed it, etc. So as the investigator, you need to be thinking, well, when I'm interviewing the person that this grievance is about, if all I've got is if I'm going to say to them, are you a bully all the time? Or are you always just undermining this person? They're going to say, well, what do you mean? Give me some examples. Um, or they might just bat it off. So it's important that you can say to them, well, look, there was an incident on the 12th of February about 2 o'clock in the afternoon where you had that conversation with the other person, and your this is what they've said you said to them. So it's important that you've got that level of evidence. So you're not just talking in generalities, and you've got specific instances that you can put to them, and you can then test that evidence. The next point is something to avoid as an investigator. There can be a temptation to say, well, it's just one word against another. There are only two people in the room, and I can't decide. The problem with that approach is, in cases involving bullying and sexual harassment, quite often these episodes happen when there's no other witnesses. And so effectively, if you say, well, it's one word another against another, so I can't decide, that means that you are essentially giving a free pass to people who may be doing that sort of behavior. And so bear in mind what Joe said about the balance, the burden of proof you're working to, which is only the civil burden. So you've got to decide on the balance of probabilities. So you're not the police, it's not beyond reasonable doubt, it's just the balance of probabilities. So you need to decide on balance, whose evidence do I prefer? And there's quite a lot of tools you've got in that. So none of these are determinative on their own, but they help build up a picture. So one is the detail. Someone who's telling you the truth about an episode may well be providing you with quite a lot of detail. Someone who is maybe not telling the truth may be giving a more high level summary. The next thing to watch is cognitive load. So if I'm talking to an interviewee and they're giving lots of hand gestures and talking quite fast, when I ask them a difficult question, they often have to pause. The hand gestures will stop, and they'll have to be they're thinking quite hard about their next answer. They're having to weigh up their answer against what they've told you previously and other evidence. When people are telling you the truth, they don't have to pause because there's nothing to think about. They're just telling you what's gone on. So cognitive load is an important one. Triangulation. What that really means is you're comparing their evidence with other evidence. Sometimes their own evidence given in emails, but some can also be, and it's often the case I find, is their own evidence given in the same interview. So if you've got a situation where you've got someone who is, if at one point in an interview they might say words to the effect of, I can't remember. And then later, when you circle back to the similar point, they say, no, that didn't happen. Well, they're two different answers. And so it's important that after the interview, because it can be difficult to pick all these things up in the interview, after the interview, when you're going back through the notes thinking, well, these are actually two different versions of events. And so I need to now go back to that person to ask them, about those different versions of events. And that's another point to remember. You don't just get one go at these interviews, particularly with the important ones, the when you're interviewing the subject of the investigation. You may need to have a couple of interviews with them where you're going over particular points they've raised and comparing that against other evidence. So next slide, please. Right. So I'm now ask you to do a bit of work. This is something that happens quite often. So you've been asked to do the interview, and what your first witness says, well, you need to interview these 16 people, and they hand you a list. So what do you do about that? So please scan the QR code and please vote. Thank you. Just get a few more people voting. Okay, we'll pause there. So there is a so there's quite a heavy, it's changing a bit, but there's quite a heavy majority in favour of asking the person what evidence they're likely to give. I have had situations where people have said, no, you need to interview them all because we need to be thorough. I think that goes beyond, because you're not the police. You only need to do a proportionate investigation, so it's probably not necessary to interview them all. I think the approach to take is that you go back to your terms of reference and you are quite upfront with the person and say, well, look, these are the questions I've been asked to look into. What's the relevance of the evidence these people are going to give? And sometimes it can be helpful to ask them to rank in order what the most important evidence is and who are the people you are most important. It's most important that you interview and why, and then you will make a determination after that. Right, so let's move on to the next poll, please. So the next question often pops up is, can people be accompanied? This is at an investigation meeting, so this isn't at a disciplinary, but they can be accompanied at an investigation interview? Mm. Oh, it's now neck and neck. Okay, so I will carry on. So the answer is, in disciplinary matters, a basic it's not a basic right. There is no right to be accompanied at a disciplinary investigation interview. There is a right, through a rather circuitous bit of legislation, to be accompanied if you're the person raising the grievance at an investigation interview. But for everyone else, there's no right to be accompanied at an investigation meeting. But the the organization, quite often, particularly in public sector organizations, lots of schools do allow people to be accompanied out by a work colleague or trade union rep in the investigation interviews. But it's important to check what the process is and what's allowed in each case. And certainly when we are doing investigations, that's one of the things we're always checking in with. Um, what do you allow? Some places say never, but others tend to be a bit more flexible than that. And off and another issue is what precedent, have you allowed people to be accompanied in the past? And so there's a variety of questions, but usually the HR person we speak to will usually know the answer to that. So next slide, please. Please, next poll. Oh no, next slide. So this is just a reminder. So when you are doing um, your information gathering, it's not just interviews are important and you'll be asking the key questions of all the relevant people, But the next one is documents. And when I'm preparing my investigation reports, the documentary evidence I find is often the most important stuff because that's the contemporaneous stuff. Let's say there's been a difficult meeting. Sometimes someone might have sent an email straight away after that while it was fresh in their mind. So that's something that you would definitely be wanting to get hold of. And also going back to those difficult situations, let's say a potential sexual harassment, it it's often worth asking the person, have they or do they remember sending any messages to anyone else? Because in a difficult situation like that, it's often the case that they won't necessarily tell a colleague, but they might send a WhatsApp to a friend or a relation. So it's worth asking, do you remember sending any messages? And so that sort of evidence is also very important, together with any meeting notes, board meeting notes or anything like that where things are being discussed. So it's important that you are gathering all of that evidence, and that evidence is as important, if not more important, than the interviews. Just a reminder, Joe mentioned about CCTV. Make sure it's not going to get typed over or copied over. Um, if there is any CCTV evidence, it gets preserved, and internet evidence. And so this is, let's say you're dealing with a situation where someone has possibly been looking at things on the internet that they shouldn't have been looking at on a, a works laptop. It's important that you coordinate with the IT team, that you, let's say, call that person to a meeting, and the IT team gets on their machine and preserves the evidence, takes screenshots, etc. So you've just got to make sure that that evidence isn't going to get deleted before you've had a chance to preserve it. So next slide, please. Right, so this sometimes happens. So you are doing your investigation. You've been asked to interview person A about the grievance that's been raised about them. They come in, they're very cross, and they say, right, I now want to raise a grievance about the complainant. So what do you do about that? Just allow you a bit more time to think about this one, because it is a challenging one. Right, we've paused there, so let's just look at these options. I think the key answer here is your role as investigator. You haven't, well, hopefully you won't have commissioned the investigation. You will be subject to the terms of reference. So you've been given your set of questions to look into. This grievance won't be part of those terms of reference because it probably hadn't happened by the time they're written. So the person to make the decision about what to do with it is not the investigation officer, it's the person who's asked you to do the investigation. So you would go, so it might get raised, that the grievance might get raised in the interview, but so you wouldn't deal with it then, but you would go back to the person who's raised it, who's asked you to do it, and say, what do you want me to do about this? And it's their decision. So it's important that you don't ignore it completely, and you don't just plow on and investigate it in that meeting. But what you often find with these grievances is it's essentially the person's response to the other person's grievance with a bit added on, with interest. And so it's often sensible. And what often happens is that the organization will want you, um, would you pause the interview or carry on? If it happens, sorry, just seeing that question come up. If it happens in the interview, I don't think I would pause because I would have my set of questions, um, and I would want to get through those questions. But if it happens before, sometimes it happens when the person is invited to the investigation interview. So you would then have more time to decide what to do about it. And I think that what, as an organization, you don't want to do is to find that you've got two investigating officers looking at essentially the same sets of facts, uh, and then making decisions, make possible two different decisions. And so what will often end up being the case is the original investigator is asked by the organization to investigate both the original grievance and the counter grievance. But the main point is it's not your call. It's the call of the person who's asked you to do the investigation. But practically speaking, it often does end up being the case that you'll end up doing the investigation as well. Uh, Next slide, please. Right. So this is one that happens quite a lot. So the interview says they want to be anonymous. So what do you do about that? Okay, so we're slowing down a bit on the responses. So let's. This often happens when you are investigating a bullying allegation, and let's say the allegation is that someone quite senior in the organization is a bully. And so it's often the case that people who possibly work for that person, or or who that person has some sort of influence on their working life and career, they may not want to speak up about it. And so there's often a request that they be anonymous. And the number of people who ask to be anonymous does start to tell its own story, and that is something that you would bear in mind as the investigating officer. But to make evidence anonymous is sometimes almost impossible. Let's say there's a difficult meeting between two people, and there's a witness to that person. There's only one witness, and that witness says, "Yes, I will speak, but I want to be anonymous." Well, it's impossible because everyone knows that that was the only witness to the meeting, so it's impossible to make the evidence anonymous. But in a broader consideration, in order to make someone's evidence anonymous, you often have to strip out so much detail that what you are left with is essentially meaningless. And when you come to put questions to the subject of the investigation about the anonymous evidence, you often find you've got very little. And so when you need to be thinking about, well, what am I left with if I strip out all the information to anonymize this person? And the other point is, well, what if I'm the subject of the investigation and I'm being faced with anonymous evidence? Well, I might quite fairly say, well, how can I respond to this? It's meaningless. Or I think someone is just making mischief and they are hiding behind anonymity to make mischief. And so a much better approach is, if someone is nervous, is to explore with them why they're nervous, what particularly they are nervous about. And it's often to do with a fear of repercussions. And so we usually would get someone quite senior within the organization to contact them and say, look, it's important that people feel comfortable to give evidence. And so if there is any hint of any potential repercussions, you come to me straight away and I will want to know about it and we will deal with it in that way. But it's really important that you're comfortable in giving evidence. And so that's a better approach we find, is getting someone senior in the organization, so the chair of trustees, the chief exec, to contact them and say, look, I'm here and I want to know if there's any potential repercussions for you, because it's important. I think it's much better to give named evidence than trying to jump through various hoops to often end up with some quite inadequate and poor quality evidence. So next slide, please. So you've gathered all of the evidence. You've gathered all the documentary evidence, and then you come to write your investigation report. And so when you're doing the investigation report, this is where you go back to the terms of reference, and the terms of reference will have the allegations or all the questions. So you will set out you should set out the allegation, the particular allegation, not all of them together, but you pull them apart. So you deal with one at a time. So you say, right, this is the allegation. This is the evidence that I gathered. This is the key evidence I gathered. You don't need to put everything in there because you will be appending all of the evidence to the report. So you just pull out the key evidence that you think is relevant to that allegation. So you will usually set out the sort of key bits of the interview notes and the key bits um, of the documentary evidence. And for a gold star, you will cross refer. You'll say it's on page 25 of the appendices that this is the full email, but this is the relevant bit that I consider to be the most important bit. So you set out all the evidence, and then you will arrive at your conclusions or findings on that evidence. And so that's where you say, look, on balance, it appears there seem to be evidence, or there doesn't seem to be evidence to support this allegation. What you should stop short of doing as an investigation officer is, let's say you're investigating a grievance, you should not be saying things like this grievance is upheld, because you're not the decision maker. It's important to remember that you are the fact finder, but you are not the decision maker. So you shouldn't be upholding any grievances, and you shouldn't be using phrases like this person is guilty of this offence or anything like that. It's you are making an assessment of the evidence, but you are not making any decisions, and it's important to sort of stop short of that. It's important to allow the decision maker enough room to make their own decisions and arrive at their own conclusions, and you are not constraining them by your your review of the evidence that you are looking at. So next slide, please. I think this top bullet point is the most important one of all the bullet points of all the slides, because there can be a temptation of starting an investigation with the goal in mind. Sometimes I've seen quite senior people in the organization say, well, look, this is our opportunity to do X about this person. I want you to find evidence on them so we can dismiss, let's say. And so you've been told the conclusion you are needing to get to, and that's the wrong approach. You as the investigator should be reviewing all of the evidence, and ideally, your conclusion should flow from a consideration of the evidence. It shouldn't be at the outset. And so you should be doing an assessment of all the evidence. And Joe mentioned earlier, it's often the case, if you've been told to investigate John for some particular conduct that he's done, you might establish through the investigation that actually this is a department-wide issue, and actually a particular practice has happened and people weren't aware of the policy, and now this practice has developed over the years, and actually the entire department is doing this. Now, if you're very blinkered and say, well, I'm only investigating John, that doesn't give a balanced overall impression. So it's important that you reflect all of the evidence. And the other point is, when you're doing your report, you should never talk about the sanctions. So if you're doing a disciplinary investigation, the question you should you're often asked to answer is there sufficient here to justify going forward at a disciplinary hearing? And that's the right question. You shouldn't be saying, oh, and by the way, I think this is worthy of dismissal for gross misconduct, because again, you're constraining the decision maker, so you are overstepping your mark. So you should never consider the sanction. It's just a question of, is there sufficient here to justify going forward as a disciplinary hearing, and possibly identifying which one of the allegations you think should go forward as a disciplinary sanction, or sorry, at the disciplinary hearing, but or you shouldn't ever go further than that and start talking about what level of sanction you think is appropriate. So, next slide, please. So, when you are deciding whether something is justified, let's say you're dealing with a disciplinary investigation, um, you it's often helpful to obviously consider your any policies and codes of practice to see has there been a breach of these. Just a reminder there, you are not the police, so you are not determining whether someone is guilty of a criminal offence. The question, this is a workplace investigation. Your question is, have they breached our own policies or codes of practice? Precedents. So how have similar situations been dealt with in the past? Just a reminder about the burden of proof, that it is um, just on the balance of probabilities, not beyond reasonable doubt. So essentially that test is it 51% or more likely that something has happened? And it's also worth just thinking, well, how do you what does a good investigation report look like? Well, a good investigation report shows your workings. So you will be saying, well, I think this is how I've arrived at my conclusion, and this is the evidence that I think is the most important. This is how I've arrived at my answer. And so the the person who's instructed you and the decision maker can see that line, that evidence. And so it should speak for itself how you've arrived at your conclusion. So there can be a temptation just to sort of jump to the conclusions, but it's important that you set out the steps that you've got there so people can follow. Someone else reading this report, you shouldn't have to go and explain this report to anyone. The idea is it should speak for itself, and so you should just be pointing them to what you think is the key evidence and telling them how you've arrived at your conclusion. And just a final point here about HR's role. The HR team are very good on things like policies, codes of practice, and any precedents, how the organization's dealt with similar situations in the past. But you as the investigating officer shouldn't be allowing HR to tell you what the conclusion should be. Those decisions should be yours, and so HR can help you with the context, but ultimately it's important that you as the investigating officer can explain and own your decision, so you can set out how you've arrived at your conclusions, what the important evidence is so far as you're concerned, and this is how I've arrived at my conclusion. So it's important that HR are are an important resource, but you don't shouldn't outsource the decision making to HR. So next slide, please. Now we're back to Joe, so I'm going to mute myself now.
Thanks, Simon. So, as we come to the conclusion of this session, I thought it'd be helpful to look at some top tips. So if you are commissioning an investigation or you're overseeing an investigation, things that will help you with that process. So one key thing, if you're dealing with a particularly complex matter that has a lot of moving parts, is keeping a chronology. I think that's really helpful, understanding and documenting when the complaint came in, who was interviewed when you made the decision to instruct the investigator, dates for various deadlines in terms of delivering outcomes, dates when you may have made referrals to regulators. all of that information, if you keep it in one place in a chronology, just helps with the management of the process, and it shows that you've got clear record keeping of what's going on, and you can keep on top of things. Um, Something else that's really important is ensuring, from a duty of care perspective, that everyone involved feels appropriately supported. Um, Quite often, the person who is the subject of the allegations can be forgotten in that process, and obviously it can become a very stressful, difficult situation. If that person is already stressed or suffering from any kind of condition that would be exacerbated by stress, you need to be thinking about potential reasonable adjustments and making sure that they are safe and well, from a duty of care perspective. And as a charity, you've got safeguarding obligations, and that extends to everybody who comes in contact with the charity. And it is there in terms of your duty of care as well, to the staff that might be involved. Managing expectations is also a really sensible thing, in terms of keeping things on track, and minimizing the scope for there to be complaints about the process. So if everyone knows who's doing what, when, what the potential time frames are going to be, you're less likely to have pushback from people who've raised the complaint or queries, because they understand the various milestones that you're meeting in that investigation, and they're expecting an update at a certain point, and they won't keep coming to you for asking for information about what's happening. And that feeds into making sure that everyone's given updates. So if those expectations are going to change because something's happened, it might be that there are more witnesses that need to be interviewed. It might be that the investigator is on holiday for a week and things are going to be pushed back for a week. Keeping people updated with those sort of changes in progress, again, is important about managing expectations. And then ensuring that the process is fair. So if you, as the commissioner of an investigation, become aware of evidence that's relevant, in making sure that that evidence is passed to the investigator to consider, making sure that the approach of the organisation is proportionate, so that the time, resource, energies, everything that goes into that investigation is proportionate to the seriousness of the issues. If it's a fairly minor uh, misdemeanor or misconduct issue that has been reported, uh, bringing in and interviewing 30 witnesses isn't going to be proportionate. So making sure that things are proportionate is good in terms of your duties as a charity in managing your resources and your finances and everything else in a responsible way, that you're putting the right amount of time and effort into that investigation. And then where possible, follow your own procedures. If you don't, there's the risk that the individuals involved will say that you've behaved in an unreasonable or an unfair way. If it's not possible to follow your procedures, then, and you need to make a variation to them, then communicate that to the people involved as well. Manage scope creep. So make sure that you're checking in with the investigator to see how things are progressing, see if anything's come up. Simon mentioned, people do sometimes raise a grievance during the course of an investigation into a disciplinary issue, or other things may come up, and just making sure that things are on track, that the investigation hasn't gone off onto a different tangent that you weren't expecting, or if it has, that you're comfortable that that's the right approach. And obtain legal advice when you need to. If the severity of the issues that have been complained of are such that you are concerned about liability, you're concerned about risk, you're concerned about managing those issues, it's really sensible to get legal advice to make sure that you're doing everything appropriately, and that you're managing that risk in a responsible way. And that feeds into trustees' duties, thinking about the Charity Commission guidance around essential trustee, acting responsibly, protecting people that come into contact with your charity, and complying with the law. So investigations can be a really important part in showing that you're discharging charitable duties in a responsible way, and that you're complying with your safeguarding obligations as charities. Um, One final thing to think about from a charity context is if the matters that are being investigated are really serious, so could result in issues for the reputation of the charity, the financial security of the charity. If they are of that nature, you may need to think about making a serious incident report to the Charity Commission. So if things come out during the course of the investigation that make it more likely that this is seen as a serious incident, the trustees of the charity would need to be informed to be able to make a decision as to whether it's a reportable issue, and that you're then complying with your charitable governance duties. And having a well-documented investigation will assure the Charity Commission that you're doing things in the right way, that you are being transparent, that you're looking into concerns, you're curious about any complaints that are coming in, and that's going to show strong and robust governance of your charity. So that brings us to an end of the main part of the session. Just so that you're aware, we have developed some e-learning for line managers. So really helpful within a charity context for managers to feel empowered about dealing with various HR issues. So if you are interested in finding out a bit more about that, and helping your staff and managers deal with investigations and grievance issues, etc., please do complete the poll now and we can get in touch with you. Just give you a second to finish that. And I think we do have some questions that have come in.
Yes.
So we can go through that. We've got a few minutes left. We've done well for time, Simon. I thought we
I
would go
know,
over,
I
but we've
know.
done pretty well.
Right, so should we start at Barry's one? So what are the challenges with beginning investigations in formal discussion? I'm not sure there are great challenges because the point is, it's just Joe said, it's a fact-finding exercise, and so I think there can be too much dancing on a pinhead. Well, is what is this? It's all essentially a fact-finding exercise, and so is it formal, informal? I don't think that it it shouldn't matter too much because I appreciate that there might be issues under a policy, but ultimately it's just fact-finding, and so I think that's I wouldn't worry too much about that.
And I think there's always
Yeah,
um, a benefit in trying to deal with things informally, but
yeah,
sometimes you have to weigh that up against the seriousness of the issues. And
yeah,
so if you had a really
yeah,
serious sexual harassment complaint, for example, trying to deal with it informally
yeah,
may not be appropriate, and then moving into the more formalized investigation stage might be the more appropriate response. But it's always good to
yeah,
consider informal processes
yeah.
first.
And the next thing about cognitive load, yes, I mean
Mm.
it's not, none of those tools are to be used in isolation. And if someone is saying, "Well, I'm struggling," and it's because of their mental health that they're struggling to answer questions sort of promptly, then that's something you could take into consideration. And it's only one tool. I think possibly more important stuff is the triangulation stuff. It's assessing, are they consistent with their own evidence? Is it consistent with other people's evidence? What's their credibility like generally? And so it's the cognitive load thing is helpful, but it's not going to, you shouldn't be basing all your findings just on how they're answering the questions, but it is something just to be alive to. And it's obviously just another point on that. That's not going to, the interview notes aren't going to show that. And so that's something you're going to need to take a note of yourself, and take a make a note of that, because that will appear in your investigation report. But the notes probably won't be showing the pauses. So let's
We've got a question here, Simon, about um, if someone is, I think the question is essentially if someone's making counter allegations of bullying and intimidation when they've been accused of similar conduct themselves, how you would deal with that in an investigation.
And this often happens. Well, you would just say, well, what's your evidence for that? Quite often when you're dealing with a bullying allegation, the person saying, well, yeah, I'm not the bully here, it's the other person. So you'll say, well, tell me about that. What do you mean by that? And it's I think with investigations, it's all about getting past the headlines. The headlines are this person is a bully. Say, well, give me some examples. To give me I remember when I was an employment lawyer, I was an employment lawyer for 20 odd years, and Mr. Tickle, who was the regional employment judge, he used to say when he was dealing with complex discrimination cases with hundreds of allegations, he would say, "Give me your best five. Give me your most serious five, uh, because if you're not going to win in your most serious five, you're not going to win on the rest." And I tend to take that view of give me, tell me the most serious examples with the detail, like when it happened, who was there, what was said, how was it said, etc. And so it's about getting past the and how did it make you feel, etc. But it's getting past the headlines and just drilling into the detail. And often you'll find that the allegation and the counter allegation are often dealing with the same meeting. Sometimes it will just be two people's perceptions of the same discussion of the same difficult meeting. And so I often find that in these investigations that what it often stems from one or two difficult meetings, uh, and then that really helps. And that's the questions asking questions like when did this happen can really narrow down what seemed to be quite a sprawling set of allegations into actually this is all relates to two meetings, and then you just get lots of evidence about those two meetings, and that can really help find a way through it.
Shall we do one final question? I think we're slightly over time now, but
Yeah,
we've got a question here about should we accept a complaint from a friend of a service user who is not actually a party to the potential complaint? So this is sort of stepping a little bit outside of a workplace investigation,
yeah,
but if you quite often have situations where someone comes forward on behalf of someone else because they've seen something or they're concerned about something, and if that something is serious, so if it's a harassment issue, etc., or it's a concern about someone's health and safety, then as an employer, you've got an obligation to look into that issue and to ensure that that issue is properly investigated. Because if it's not, and people are at risk as a consequence, then you're going to be liable. So just because it might not be the person who's the heart of the issue who brings it forward doesn't mean you shouldn't look into it.
mm,
Um, but you should always, and Simon, you've probably got a view on this, you should always try to speak to the individual who is at the heart of it because they're going to be a key witness and to see whether they want to pursue it or what they want to
mm,
achieve from that
yeah.
issue. And that's likely to come out in the investigation.
Yes, no, I think that's right, and it's these things often come about. These investigations often come about from a complaint that's been made by someone. So it's often dealt with initially through the complaints procedure, and then it turns into a a workplace investigation following the complaint from someone external. So that's often the route in, as it were, to these investigations.
So I don't think we've got time for any more questions, unfortunately. But if we haven't got back to you, we'll try and respond after the session.
Yes,
You will all receive a link to today's recording and copies of the slides. And just leaves me to say thank you very much for attending. It's been really nice speaking to you this morning, and enjoy the rest of your day.